I have something they need, and then they have something I need. So it's an exchange. I never thought I could be arrested for that.
Sex work is a crime in South Africa, but making it illegal to be a sex worker only makes it harder and more dangerous for women to do this very difficult work. They're constantly under threat of arrest, and if they're a victim of a crime, they feel it's pointless to go to the police.
Last time I was robbed, and then they took my money, and bad things happened to me. I was raped. I went to the police. Till today, they didn't do anything. When you go to the police, they ask you, why didn't you stay home?
These police, they put us in a wet cell. I was freezing cold. They have no evidence. You don't even appear in front of the judge. I have never stood in front of a judge in all these years.
Although Department of Health is saying here are condoms, some sex workers fear carrying condoms because that then means you are almost telling the state, I am a prostitute and I risk being arrested.
When they confiscate these condoms from sex workers, in many instances, police are the ones who are asking favors from sex workers. We are saying sex work must be decriminalized so that our sisters cannot be abused, cannot be killed.
All these sex workers want is to be protected by the law, to be able to walk into a police station and report cases, not being put in an exploitative situation where the brothel owner or somebody else has more ownership of what they do or their income.
I'm Cecelia Cock, and this is Landmark Judgements, a show about South Africa's major constitutional court cases. This series is brought to you by the Friedrich Naumann Foundation for Freedom. The case of S versus Jordan and others is about the constitutionality of sex work. The judgment is split into a majority of 6 and a minority of 5. There is a lot of agreement between the two. Both the majority and minority are clear in holding that the regulation of sex work is the prerogative of Parliament. Both hold that the criminalization of sex work is not an unconstitutional infringement on sex workers' rights to human dignity, economic activity, privacy, nor on their right to freedom and security of the person. The only significant point in which the two judgments differ is in respect of the right to equality. But this disagreement is only in respect of a single aspect of this expansive right, namely gender discrimination. The majority finds there is no direct discrimination on the basis of gender, as both female and male prostitution is illegal. For 2 reasons, it also finds that there is no indirect gender discrimination. First, it holds that there is a qualitative difference between a sex worker, who is likely, in the court's words, to be a repeat offender, and a customer who, again in the court's words, may not be a repeat offender. Second, whilst the particular piece of legislation at issue only criminalizes the conduct of the sex worker and not that of the customer, the majority holds that the customer is liable as an accomplice to the crime under common law, and that thus there is both criminality on the part of the sex worker and the customer. The minority judgment finds that there is unfair gender discrimination because the vast majority of sex workers are female, and I quote, "The effect of making the prostitute the primary offender directly reinforces a pattern of sexual stereotyping, which is itself in conflict with the principle of gender equality." The minority holds that, and I quote again, "The indirect criminal liability on the client, assuming there is such, flows only from the crime committed by the prostitute." The minority concludes that both the conduct of the sex worker and that of the customer should explicitly carry equal criminal weight. I sat down with advocate Wim Trengove to talk about the case.
I was briefed by the state in defending the Sexual Offences Act, and more particularly those provisions which criminalized sex work. There were 2 arguments. The main argument was that it unfairly discriminates against women, because sex workers are mostly women, and the act criminalizes the conduct of the seller of sex, i.e. the woman, and not the buyer, i.e. the man. So there was that argument that it unfairly discriminated on the grounds of sex or gender. There was also an ancillary argument based on ancillary arguments based on the right to dignity, the right to free economic activity, and so on. But they were never really viable. It was the equality argument that was the main debate before the court.
The right to equality, I mean, that could mean a lot more than simply the fact that the particular act in question failed to treat women and men equally. It could be a bigger one in the sense that, prostitutes ought to have equality of, practicing their trade, economic trade or economic freedom, and they simply don't have that kind of equality. Is that something that ever came up in the case? Because it doesn't seem to have been mentioned in the judgment.
The equality issue was debated at two levels, and you see that in the judgment. I think there's a third level that was never addressed in the judgment, and which might have been more debatable. But the question whether the prohibition of selling sex, basically, of sex work, whether that discriminates between men and women, can at its most basic level be argued on the basis which I did, namely that the act prohibits the sale of sex. In other words, having sex for reward. And it doesn't limit that prohibition to women. Anybody who has sex for money commits that offense. So on that very basic level, one can argue there's no sex discrimination because the prohibition applies equally to men and women. There's the second level, and that's the debate that was really had by the court in their judgments, and that's also where the majority judgment and the minority judgment differed, and that's this. To say that it may be so that the act punishes only the seller, it may be so that in its language, the act punishes the seller of sex, whatever his or her gender might be. But the fact of the matter is that the seller is usually a woman and the buyer is usually a man. And by punishing only the seller and not the buyer, the prohibition discriminates between men and women. To that point, the majority of the case eventually split, I think 6-5. The majority of 6 answered that point by saying that although this particular section only criminalizes the conduct of the seller, there is another provision of the law which makes all accomplices subject to the same penal provision as accomplices. It happens to be under the Rioters' Assemblies Act. But it means that when a man, although the particular offense is committed by the seller, mostly a woman, the man who has sex with her is an accomplice to that crime and therefore liable to the same punishment as the woman. And therefore, said the majority, there's no sex discrimination because if you read the Sexual Offences Act and the Rioters' Assemblies Act together, they punish both the seller and the buyer of the sex. The minority judgment differed from the majority on that basis because they said, yeah, that may be so in literal terms. But the fact of the matter is that the Sexual Offences Act brands the seller, i.e. the woman, as the principal offender and thereby stigmatizes her role in a way that it doesn't do in relation to the man's role. And that's where the majority and minority differed from one another. The minority held that it was that there was unjustified sexual discrimination. I always thought that there was a third possibility.
That's what I also think is missing.
Which was never argued. Well, or if argued, in any event, didn't come up in the judgment. And that's this. Sex work is, or was at least at that time, we're talking early 2000s, mostly work performed by women. The overwhelming majority of sex workers were women. So if you, a law which criminalizes sex work, criminalizes the work performed mostly by women. So what you really do is you take a slither of conduct, which is mostly the conduct of women, and then you criminalize that conduct. And it seems, and the fact that work is mostly done by women is not unrelated to their sex or gender. It is very closely tied to their sex or gender. It is selling their sexual services. So it's closely tied to their gender. It's not like robbery. Others might say, yes, but robbers are mostly men, and therefore your prohibition of robbery discriminates against men. I think that's a false argument, because there is there's no close tie between gender and crime in that instance. When you're talking about sexual offences, there's a close and intimate tie between the fact that this offence is normally committed by women, or mostly committed by women, and their sex or gender. And then to say that I'm going to intervene and prohibit that offence seems to me to strike at women in particular. And the question then is it justified to strike down a crime which is committed mostly by women because they are women? And that question was never asked and never answered. And I think it's far more difficult to answer the question then, when one has to justify the criminalization of conduct which is peculiarly or mostly feminine.
I think that's certainly an argument that could be made. And I must say, I feel like there's one that can even be made without even looking at gender. The court definitely has a view, even both in the majority and in the minority judgment, that the body is sort of a sacrosanct thing, and it's not something to be sold. But we see people engage in hard labor all the time, and yet that's not condemned. And it is certainly a use of the body in a very excruciating, often, and a very difficult under very difficult circumstances. So there too, there would just seem to be, without even mentioning gender, an inequality of people to be able to sell.
Yeah, it's a moral judgment
things
about the way in which people legitimately use their bodies or not.
That's it.
Let me say this in defense of the prohibition is this. In making the argument, I was very careful not to try and argue that sex work is a good thing or a bad thing at all. That didn't ever feature. The crux of the debate, the legitimate debate, is this, that we know worldwide that there are all sorts of social ills inevitably associated with sex work. And there are very many of them, and that part of it is common cause. And the question is how best to address those social ills. And the fact of the matter is that you will find worldwide that it is done in one of three ways. Firstly, by prohibition. That's the route we choose. Parliament chose. The other one is by regulation, and the other one is by just abstention, free for all. And there is no universal consensus that it should be, which one of it should be. All of them are flawed in one way or the other. And the question is does the Constitution allow Parliament to make that judgment call of which is best for us? Some societies have a system of close regulation, which might be a better way of doing it. But we know that in our particular society, our regulation doesn't work well. You can look at our traffic to know that we're not good at enforcing regulation. So you must allow some latitude to Parliament's choice. Firstly, by the fact that there is no obvious answer, and secondly, due to the fact that our particular circumstances doesn't allow us all of the options that other societies might have.
Isn't that putting the cart before the horse, though? Wasn't the court asked to pronounce on whether selling sex was, legal or not in terms of constitutional rights, as opposed to, asking the court how to deal with the social ills associated with it.
Yes, you're quite right. But remember, the question was not, is the way that Parliament has chosen to do it the best way of dealing with sex work? The question is it a constitutionally permissible way of doing it? And when you judge whether it's a constitutionally permissible way, there are really two parts to that inquiry. You ask firstly, does it breach any of the provisions of the Constitution? In this case, in particular, does it discriminate between men and women? But even if you then find that it does, there is a second phase to the inquiry, and that is it a justifiable limitation? And that, broadly speaking, means, is it a limitation which is acceptable in open and democratic societies? Well, if you look around you to the open and democratic societies all over the world, our regime is certainly not peculiar. There are very many countries in the world where the same approach is adopted. I don't think it's the best approach. I think the Scandinavian approach is far better, where the conduct of everybody in the sex trade is criminalized except that of the sex worker. And the sex worker is provided with social assistance to help them, if they want help, to find other ways of making a living. But whether that is feasible in South Africa is a moot question. In our society, individuals are allowed to do everything which is not legally prohibited. So the starting point is that prostitution is lawful and constitutional unless and until Parliament prohibits it. Well, that's what Parliament did in this instance. And then it is the law which becomes subject to scrutiny rather than the underlying conduct. Parliament is entitled to regulate society in whatever way they think best, provided that they do so within the parameters of the Constitution. So when Parliament makes a law, as it is entitled to do, the only question the courts are entitled to ask is whether that law is permitted by the Constitution, and that's what they did in this case. I think the question was ultimately not sufficiently intensely debated. I think those two levels at which the debate were had were pretty superficial levels. I think there's a bigger question that was never addressed. What this law really does is, regardless of the terms in which it does so, the effect of what it does is to outlaw a trade mostly applied by women. And in that way, it discriminates against women. And the question is whether it is legitimate to do so. If you take the majority and minority judgments, what they have in common is that all of them agreed that if the law prohibited the conduct of both the seller and the buyer in equal terms, then it would be perfectly constitutionally kosher. And I don't think that proposition is necessarily enough. I think there's a further question to be asked. If the prohibition is a prohibition of a trade mostly applied by women, is it constitutionally permissible? And I think that's a harder question. It really is.
How big a mark do you think that leaves in the particular case that we're discussing, so in the S versus Jordan case?
They were highly respected lawyers on both sides. As it happens, but I do accept that one's inclination may well have tended to predispose those judges to one side or the other. I also know that in the particular case, Justice Mokgoro was on long leave, and Justice Du Plessis from Pretoria was acting in her stead, and he was one of the majority judges. Now, whether the balance would have been different if Mokgoro had been there is a nice question.
What about an argument built on the basis of the right to dignity? Because sex work is criminalized, sex workers are particularly vulnerable. They cannot easily seek help if they are abused, maltreated, or exploited because they risk criminal sanctions. Many sex workers are forced to endure great hardship because of the risks involved in speaking out. This surely leaves one with little dignity.
Yes, I actually don't think that that argument should prevail. Let me tell you why. I do think that if you legalize sex work but regulate it properly, that you will certainly alleviate the plight of the individual sex workers where there's a prohibition. They're exposed to abuse by not only the cops, but their pimps and their clients and society at large. The other side of the coin, though, is that if you legalize it, experience worldwide has shown that you then have you reduce the abuse of the individual sex worker, but you don't eradicate it. There is still, for a variety of reasons, lots of abuse of sex workers, even in societies where sex work has been legalized. And what you do by legalizing it is you trigger a very substantial increase in the volume of sex work because it is now a legal activity and not an illegal activity. So although the individual sex worker's plight might be improved, the social issue is multiplied many, many times. So you sit with a far bigger industry than you had before. Whether a small industry with intense abuse or a big industry with milder abuse is a preferred route, I'm not sure, but that is the counter argument. I have little doubt that legalization and proper regulation is the better way to do it. But remember, the question in the case is not what we think the better way is. The question is whether the way chosen by Parliament is a constitutionally permissible solution. The outcome of the case does not mean that the Constitution requires sex work to be prohibited at all. The outcome of the case simply means that the Constitution leaves it to Parliament to choose how to deal with sex work.
Why was that never explicitly sort of stated? I would imagine that this would be a central issue in the case. Why is
it should be. I think
feature?
lawyers understand that is so, but I agree with you that the public perception may be that the Constitutional Court and the Constitution are against prostitution, and that is not what the outcome of the judgment is at all. The outcome of the judgment, the case is about the Parliament's freedom to deal with sex work in the way that it deems most appropriate. The judgments say that provided you treat the seller and the buyer equally, the prohibition is constitutionally permissible. Well, that's a pretty shallow conclusion.
To what extent do conservative views about sex play a role in this judgment?
I have little doubt that our old conventional attitudes about sex and sex work played a part. But let me give you the court's answer. The court's answer is yes, sex is a deeply personal and private activity. But the moment you commercialize it and make it available to all comers in the market, then it becomes a commercial enterprise and no longer a deeply private undertaking. So there's some truth to that.
So an interesting thing to think about in that regard is Tinder, for example, or Grindr, where there's a very public engagement with other people around hooking up, having sex, just going on a date, and that aspect of things is quite public. Whereas once that's done and that's out of the way, and you go and do whatever it is that you want to do, that realm seems to be rather private.
No, you're quite right. Those lines are shifting. After my time, I'm afraid, but they are shifting. But it's also not surprising. We must accept that these values evolve over time. The treatment of the death penalty, for instance, is an example of where societal values evolve over time. And what is conventional wisdom today might have been anathema in the past. So, yes, they evolve, but Tinder wasn't yet here in 2002. One is not dealing purely with a notional transaction of a sexual encounter between two people and for which money is paid. One is dealing with a very complex and a very serious social question, because the social ills associated or that go hand in hand with sex work are serious and justify government's intervention in some appropriate way, whether that is by prohibition or by regulation or by whatever is a different debate. But I don't think that there is a case. I don't think that it is a defensible proposition to suggest that Parliament doesn't have the right to legislate in relation to sex work at all. The question is how it should go about doing so.
These two questions, the one of constitutionality of the conduct and the one of constitutionally permissible ways of dealing with the conduct, to me seem to be intricately linked. Once it is determined that the conduct is constitutional, or then that will certainly have an impact on the second question. Is that not so? And that's why it's very difficult to answer the question, the second question, without answering the first.
But the legal question is not whether the underlying conduct is constitutionally permitted or prohibited. The legal question is whether Parliament's choice to legislate in a particular way is permitted by the Constitution.
But if it affects that particular conduct, doesn't that question automatically have to be answered first in order for one to answer the second question?
Well, when Parliament, for instance, prohibits certain conduct, the question still is the prohibition constitutionally permissible? When you answer that question, you would certainly go to the conduct and say to yourself, is Parliament entitled to interfere with this conduct at all?
Yes.
For instance, there's US jurisprudence on whether birth control may be prohibited. And the consensus there was that that is an issue so intimate between the parties to a sexual encounter that it's not legitimate for government to interfere with it at all. So that's a conclusion which says, is the law permissible? The answer is no, it isn't, for the reason that you mentioned, and that is that the underlying conduct is so personal and so intimate that government shouldn't interfere. But with sex work, there is greater justification for interference, not because of anybody's moral disapproval of sex for money, but because it goes hand in hand with a serious social issue, and it's legitimate for government to legislate for the control of that social issue. The only question is, what is the way in which it should be done?
I mean, you talk about the social ills. What is interesting is that in the actual judgment, there is so much mention of, the sanctity of the body, the sanctity of sex, and that kind of thing. And even in the minority judgment, there's just a passage that I just thought I'd like to read out. I mean, one would think that if these arguments are irrelevant, they wouldn't be on the pages, but they seem to have made some impression on the judges making them. So the minority judgment reads as follows. By making her sexual services available for hire to strangers in the marketplace, the sex worker empties the sex act of much of its private and intimate character. She is not nurturing relationships or taking life-affirming decisions about birth, marriage, or family. She is making money.
That was Saxon O'Regan, wasn't it?
That's right.
There you are.
You're doing something bad because you're not treating sex the way it ought to be treated. But if that's the case, then we should look at all casual sex in the most horrified manner.
Yeah.
It speaks to a certain kind of mindset, I suppose.
You must also remember that this legislation is very old, and it speaks language which is very foreign to us. It's really very old, archaic English.
Have you been at all involved in other cases relating to sex work?
Yes, more than one. I can't remember. I certainly remember, oh yes, at least 2 cases. I did another case in Cape Town for SWET, that's the sex workers lobby group, because sex workers were being harassed by the Cape Town police. The NPA had actually taken a decision not to prosecute streetwalkers, so there was no prospect of their prosecution. But the cops used to round up street workers on a Friday afternoon and just keep them in jail over the weekend, only to have them released on Monday morning because there was no prospect of a prosecution. And that was merely to harass them and to, quote, clean up the streets. So I acted for SWET, and we got an interdict against the police because the court held that it was unlawful for the police to arrest sex workers, well knowing that they would not be prosecuted. In other words, to arrest them merely to punish and intimidate them and not to prosecute them. So that was a victory for sex workers. There was another wonderful case I did for a woman who was called Kylie, but it was a pseudonym, who was a sex worker who worked in a brothel and was then fired for breaking the rules. And I then acted for her in suing the brothel under the protection of the Labour Relations Act. And we ultimately succeeded in persuading the court, only on appeal, that the Labour Relations Act also protected sex workers, even though their work was illegal. So that also made, I hope, a difference, and I hope redeemed myself with the sex workers.
I remember that case well.
Yeah.
I sat down with former Constitutional Court Justice Kate O'Regan. Together with Albie Sachs, Kate wrote the minority judgment in the Jordan case.
Would be apparent to anybody who reads judgments that the judgment that Albie and I wrote was, in fact, the first judgment written. It's the longer judgment by a significant way. It deals with all the facts, and it was written, therefore, to be a decision of the court, not to be a minority dissenting decision. That happened in quite a few matters, and it's pretty obvious to somebody who reads the judgments when it has happened, but not many. I mean, it happened, but it was not by any means the most common thing to happen. But the view generally taken was the scribe who'd been allocated a decision should write the decision as they saw the outcome. They weren't obliged to write the view that the majority had expressed at conference. So that's how it happens when it happens, is that the scribe writes a particular view and then the rest of the judges decide they don't agree with it.
Can you tell us about the reasoning that you found the particular section in the Sexual Offences Act to be unconstitutional?
So, and I hadn't looked at the judgment for a long time, but the key issue in the case was the fact that the legislation criminalised the conduct of the person who was making sex available for a fee or for a charge, and not the conduct of the client. And the judgment that Albie and I wrote took the view that there was a gendered element to the way in which the criminal prohibition worked, to criminalise the person who is the purveyor of sex and not the client. And that's unusual in our law. Generally, if the law prohibits a particular form of commercial transaction, it prohibits both sides of it, criminally, corruption, for example. So we felt that not only that, but the kind of gendered nature of the way in which commercial sex operates rendered that to be unfair discrimination. And I remain surprised that that wasn't seen to be the case by the majority of the court. It was quite a narrow way to decide the case, that's true, but I didn't think that it would be, I still think it constitutes unfair discrimination. The majority cited the fact that it would be possible for the client to be charged as an accessory or in some form of the kind of common law liability flowing from being in some way engaged in the criminal offence, but of course there was no evidence for us that it ever happened. And it just seemed to us that it just spoke of, by and large, prostitutes being seen as carrying the burden of criminality and not clients. So that was the main decision upon which we differed. This decision is one of those examples where the challenge for the court is to determine the legitimate terrain of human rights or the Bill of Rights and separate it from the legitimate terrain of politics. And I think that remains a challenge for human rights jurisprudence in every jurisdiction and in every part of the world. What is it that we're going to put beyond the terrain of politics? And given the importance in South Africa of a democratic state and the achievement of a democratic state, I have a sort of general working view that we should not close down the terrain of politics in circumstances where we are not sure what the right answer to the particular social problem is. We should allow the domain of politics, and I think it's written into the way in which Section 36 works, which is to say that rights may be limited if justifiable in an open democratic society, recognizes that there are ways in which rights may be limited through the exercise from the domain of politics, because it's got to be law of general application, in a way that is justifiable. And I think that is what was underpinning the Jordan approach, was that there is no doubt that there are different ways for systems to respond to dealing with prostitution. We may have our own moral views as to what that is, and I do, and I'm sure you probably do. The real question is, to what extent are those moral views, should they determine what the law says about the domain of politics? There's no doubt that for Parliament to opt for decriminalisation would be a constitutional option available to Parliament. What we didn't want to do in the decision, and we expressly kept it open, was what is now being considered to be the Scandinavian model and widely accepted in Scandinavia and increasing number of countries around the world, which is you criminalise only the conduct of the client and not both. We weren't sure what we thought about that from a policy point of view, but what we were more sure about was that we weren't wanting the court to close that possible debate down as a way of dealing with prostitution. And it wouldn't mean that if it were argued again that the court might come to a different view on that, but it really is about this preserving a space for the legitimate terrain of politics. And that's democracy is one of the key reasons for that. But it's also the capacity for the way in which Parliament in particular, when working optimally, goes about its business, that enables it to get a range of information to make these difficult social judgments in a much more coherent way than courts. So it's both about the democratic importance of leaving these decisions to democratic representatives of the people, but also the institutional suitability of Parliament and its ability to change its mind and refresh and refine the decisions it takes in circumstances where the correct social policy is a matter of some vigorous debate and it's not clear what the right way forward is. So I think that informed the decision. As I say, it's a difficult call at times how to draw this line between the terrain of rights and the terrain of politics. But generally my view is that where it's clear that a range of possibilities exist, we shouldn't too quickly close down on politics' capacity to make the decision.
So counsel for the applicants really argued very strongly on the basis of rights and argued that certain rights were being infringed. And one of the arguments put forward was that the rights to dignity, freedom of the person, and privacy really they exist because they further the value of autonomy. In your judgment, you and Judge Sachs wrote that there was no separate right to autonomy. But does one need to posit a separate right to autonomy in order to deal with the concept of autonomy? Or can one simply say, well, why do we have these rights in the first place? We value them because they allow for autonomy to flourish and they allow for a self-determined life. And do you think now you would have dealt with autonomy slightly differently, or were you happy with the way autonomy was dealt with?
I do think autonomy is very important in the Constitution. There's no doubt about it, as something that informs a variety of the rights. And arguably, there would be legal theorists and philosophers who would say that it's the capacity for autonomy that is the foundational principle of human dignity and therefore the foundational principle of human rights. There's, needless to say, a fairly vigorous philosophical debate about that, but it's certainly got a very powerful intellectual and moral cogency. But I think that so this is another of those cases that deals with this complex question around, on the one hand, wanting to value and further autonomy, and on the other, recognizing that there's an enormous amount of harm out there in the reality of the world, and that at times people make decisions which are harmful for them. So, true liberal position would say, well, of course, this is not the duty of the state to say to people that you can't do that. But of course, actually, the state does that all the time, and we recognize that, in fact, we do want it to do that all the time, whether because we are trying to protect against harm. And how do you draw the line between when is autonomy something that is harmful? And for me, I have to say that I remain concerned about the harm that I think that is related to prostitution more broadly, human trafficking, the issues around healthcare, around violence against prostitutes, and I think we do need to deal with that. So it seems to me to be a very complicated social question, which I didn't think the court had an enormous amount of information before it on. If I were to be trying to inquire into it, I think there'd be a lot more information I'd like before I would work out exactly how to draw the line between autonomy and protection, which I think is something the state is endlessly engaged upon.
So you make this point about autonomy and harm, and the fact that people, might make very bad decisions regarding themselves that stand to harm them as well as others. But would criminalization not exacerbate that harm as opposed to sort of alleviate it?
I'm sure you may well be right, and I think it'd be interesting to look at the studies about this, and I think it can. I do think that it really wasn't the issue before the court, and I'm not a social scientist, but I do like to see evidence before I take a view as to whether something will or will not cause greater harm. And we just didn't have that data before us. It wasn't really the question before us, and I think that sometimes if one's thinking about the big picture of the separation of powers, I do believe that it's better for courts to decide things on narrower bases rather than broader bases, because what you then do is you almost work in partnership with the legislature. The thing has to go back to the legislature. They have to think about it again. And where the answers aren't clear and aren't self-evident, then it's good to have an institution which is designed for these sorts of debates to take place, to have the debate. So from a separation of powers point of view as well, I think deciding narrowly is sometimes a good thing to do, and to let the debate take place in the proper forum. I think, there are times when the court has to do things which are both very high profile and unpopular. The death penalty, for example, gay marriage. There are things the court has to do because there's no real social doubt about what the right answer to the question is. Where there is social and rights-based doubt about what the right answer to the question is, given a limitations clause which allows limitations, then I think the court should be much slower to say this is the only right answer when there are a potential array of right answers. When there is only one right answer, then the court shouldn't shirk that. Legitimacy or no legitimacy, that's the task of the court. So it's really about this question of, is there more than one way in which this right could be, or this issue could be addressed in a rights-based way, which would nevertheless pass muster under Section 36. Those are the circumstances in which a court should be slow to basically close down on what effectively is Parliament's right to seek to address an issue, even if it involves a limitation of rights, as long as it does so in a way that's reasonable and justifiable. And the truth is that there are many sorts of reasons that could be reasonable and justifiable. Some of them could be that we're seeking to protect rights, or other people's rights in having this limitation. But they could also be there are other purposes here which are not rights-based purposes but are nevertheless important purposes for the state to pursue. So I think that's the real fulcrum of the question. It is very, very important for the court to look very seriously at the reasons that are produced by Parliament or the executive. And I think that's so because the centre of any democracy, the centre of decision-making in any democracy, remains the legislature. And it's that, as I've said, both for democratically legitimate reasons and for reasons of institutional suitability. And Section 36 is designed to ensure that when a court is considering a limitation on a right, it looks extremely carefully and with great respect at the reasons that are produced by Parliament for any particular limitation. And it's only if the court considers that they're not reasonable and justifiable would the court strike the legislation down. In this case, I think that as a minority position, Judge Sachs and I felt that the reasons that were given for criminalising only a person who's selling sex was unpersuasive and didn't constitute a reasonable and justifiable account of why you should select out one person in a transactional arrangement, and that Parliament should go back and think about it, and that they should think about the whole question.
I would just like to come back to some of the rights that you dealt with in your judgment. So one of the rights that you looked at in some detail was the right to human dignity. And you, in your judgment, speak about how human dignity also involves the human body, and how the body isn't supposed to be commodified or should not be commodified in order to preserve dignity. The thing is, a lot in my rereading of the case seems to have hinged on the nature of the Sex Act, so the fact that it wasn't loving or nurturing. But then again, we're fine with that happening, with people all the time, as long as there's no. Well, I mean, I don't know if we're fine with that happening. The point is that the state doesn't get involved. And why is there such a difference when money changes hands? Is the question, I guess.
Yeah, I think it's a difficult question. I think the one of the things one has to realise about rights is that I disagree with an approach that's been increasingly aired, which suggests that one should give rights the broadest possible meaning and that all the work is done under justification. I think that's wrong. I think rights actually should be quite muscular, should have quite clear purpose, and they're not floppy things. And we value them for particular reasons, and we should air what those reasons are, and then we might disagree with them as you're suggesting now. I think in relation to privacy in particular and dignity to some extent, there are a lot of things that we can say we fall within a broad sphere of privacy and dignity, but not close to its core. And I think that sort of reasoning, which is that the core of privacy and dignity in relation to human relationships is the establishment of loving, meaningful relationships where people take on responsibility for one another, seems to me to, something upon which we can reasonably disagree, but upon which I still feel quite strongly, actually. And that as you move away from that, it doesn't mean you move outside of privacy, but you move into a less sharp area for privacy. So my right to sell anything, whether it's sex or cigarettes or cakes, is not as close to in privacy as my right to have privacy with a family home and in an intimate partnership relationship in a bedroom. That seems to me to be much less close. And I think we said in the judgment that one of the complicating things about this decision is that, on the one hand, selling things is something that's in the public sphere and generally wouldn't attract a lot of privacy, whereas once you're dealing with sex, it does have some privacy implications, there's absolutely no doubt about it, but they're not as intense as other kinds of privacy. So I think the judgment was trying to grapple with recognising that you need to treat the right seriously and you need to treat the nature of the invasion of the right with seriousness, because if you don't do that, when you come to the proportionality analysis, you haven't got anything to weigh fully on the one side of the scale. And I think that's what that element of the judgment was saying is that if, for example, under the Immorality Act during apartheid, there was a prohibition of sex between people of a different colour, that was a much more egregious violation of the privacy right than a prohibition on prostitution. And I still believe that. And that's partly because of the character, that there is something that changes the privacy nature when something becomes merchandise from when it's a personal relationship.
I suppose one can also think about prostitution in sort of two separate spheres. So the changing of money is sort of a public thing, and it, you know, falls under contract law and all that kind of thing. But then you've got the Sex Act itself, which does happen behind closed doors. Well, I mean, it depends on how it happens, really. But yeah, you know, what generally happens.
Yeah, and that's the private aspect of it. And I do accept that has real privacy implications. It's just not right at the core of privacy once it becomes commercialized. And, you know, we can disagree with this. I don't think that agreement on rights is, obvious. In fact, reasonable disagreement seems to be part of the exercise. But it is important for courts to try to grapple with why we feel differently about the Immorality Act, or why we feel differently around a prohibition on prostitution.
I also just wondered to what extent this the reasoning is relevant to apps like Tinder or Grindr. You can actually pay for a particular kind of subscription to Tinder, which allows you, certain access or whatever. And I wanted to, because I'm pretty sure that not all hookups that happen through Tinder or Grindr end up being meaningful, nurturing, loving relationships. So how would we look at them in light of the Jordan case?
I feel about that as I would feel about prostitution, relationship of paid sex, that the people engaged in them have got a legitimate expectation and right to not have those broadcast on, the internet. If that's one of the questions about Tinder, should this be published and broadcast? No, I think one's privacy does protect you from that. But the more difficult question is, if the state were to take the view that actually Tinder is producing great harm, and they had evidence that that there were a lot of very abusive relationships and potentially trafficking, etc., flowing from Tinder relationships, should the state say we shouldn't have Tinder, or certain types of relationships should not be permitted by Tinder, either as an imposing obligation in the first place upon Tinder and or upon the people who engage in it? Do we then feel that's problematic? And again, I think these are complex questions. I don't think we should be overly sanguine about or overly confident that relationships between people are not brutalizing and deeply problematic and deeply harmful. We're living in the era of Me Too. We're now beginning to come to terms with some senses of the inequalities that underlie many sexual relationships and engagements, and I don't think necessarily it's a place from which the state should never go. I probably err myself on the side of thinking, these are such messy things for the state to get involved in. I'm not sure if I were a legislature I would deal with it, but it's not my decision at the end of the day. These are complex questions which I do think properly belong in the terrain of Parliament, for it to think and talk and decide on the basis of evidence presented before it as to what is harmful and what not harmful, and democratically take a decision for which they'll be accountable.
Writing about the legislation, the majority states that the Act pursues an important and legitimate constitutional purpose, namely to outlaw commercial sex. The minority echoes this sentiment when it writes that the regulation of sex work is a legitimate sphere of the legislature in an area of considerable public controversy. Did the court put the cart before the horse? For example, in dealing with the right to economic activity, in all of 4 short paragraphs, the majority states that measures intended to eliminate the harmful effects of prostitution and brothel keeping are clearly measures designed to protect and improve the quality of life. It is not for this court to pass judgment on the effectiveness or otherwise of the choice made by the legislature. Could the court have engaged more substantively with the constitutional rights the sex workers claimed were being violated? Or was there something driving a disinclination to engage more in depth with the constitutional questions raised in this case? The minority states, and I quote, The question of commercial sex must be looked at not through the lens of certain popular conceptions of morality, but through that of constitutionally articulated values. However, is it not possible that constitutional values and rights may be interpreted by judges through a very particular lens of morality? Let's read a few sentences from the judgment. By engaging in commercial sex work, prostitutes knowingly accept the risk of lowering their standing in the eyes of the community. In using their bodies as commodities in the marketplace, they undermine their status and become vulnerable. Although prostitutes do constitute a vulnerable group, this is due in some part to their own conduct. The evidence suggests that many women turn to prostitution because of dire financial need and that they use their earnings to support their families and pay for their children's food and education. We do not regard this as an excuse or a justification. To the extent that the dignity of prostitutes is diminished, the diminution arises from the character of prostitution itself. The very nature of prostitution is the commodification of one's body. It is not the intimate expression of sexuality that is inhibited, but only its commercial aspect. The prostitute makes her sexual services available to all and sundry for reward, depriving the sexual act of its intimate and private character. No invasion of privacy takes place at all. Commercial sex involves the most intimate of activity taking place in the most impersonal and public of realms, the marketplace. It is simultaneously all about sex and all about money. Central to the character of prostitution is that it is indiscriminate and loveless. By making her sexual services available for hire to strangers in the marketplace, the sex worker empties the sex act of much of its private and intimate character. She is not nurturing relationships or taking life-affirming decisions about birth, marriage, or family. She is making money. Okay, so those were all quotes from the judgment. We'll leave you to ponder the matter further. Thank you for listening. I'm Cecelia Koch, and this was an episode of Landmark Judgements, a show about South Africa's major constitutional court cases. This series is brought to you by the Friedrich Naumann Foundation for Freedom.